if you do address it and say it's because it's hopeless, that's why I'm not letting you in, whether that would be enough.
Well, in my submission, in both scenarios, there would be no right of appeal.
Right. Okay.
Given the questions that Lady Millard, you asked, may I just take you straight to the policy and then to the decision, and then you'll see how the policy is being applied. So if you go to tab 24 of the authorities bundle, you'll see a policy considering human rights claims in visit applications. And if you go to page 480 of the bundle, you'll see a heading, has a human rights claim been made? And under that heading, you'll see the policy requires the decision makers to consider for question, does the application say that it's a human rights claim? Does the application amount to an implied human rights claim? If it does not say that it is a human rights claim, there's no dispute about those two questions. The third and fourth questions are relevant to this appeal. Are the matters raised capable of engaging human rights? If no, then refuse the claim with no right of appeal. If yes, then the next question would be, does the human rights claim have any prospect of success? If no, then refuse with a right of appeal. And if yes, then refer to a different unit. So in other words, if the decision maker takes the view that what is being said is not capable of engaging Article 8, there would be no right of appeal. But if the decision maker takes the view that what is being said is capable of engaging Article 8, but decides that a human rights claim is not made out, it has no prospect of success, that would be a refusal of a human rights claim, and the policy says that there ought to be a right of appeal. And if you look at the next few pages, you'll see further guidance as to those 4 questions. There is no controversy about questions 1 and 2, so I'll go straight to question 3, which is at page 483 of the bundle. And you will see that the guidance includes guidance on what is meant by engaging human rights and how to consider whether human rights are engaged. And you'll then see a heading, Article 8, Private Life. And what is said is that the only relationships that may engage Article 8 in visit applications are spouse, parent, minor child. That, as I shall explain in due course, is actually based on case law jurisprudence. But even where a claim is based on one of these relationships, the starting point is that Article 8 is not generally engaged where a visa application is refused. So this is question 4, and if you look at page 486, you'll see question 5, whether human rights claim has any prospect of success. If there is none, then refusal would follow, but that would be a refusal of a human rights claim, attracting a right of appeal to the tribunal. Now, whether the submission is that this policy accurately reflects the law. The question for this court, in my respective submission, for the purposes of jurisdiction, is not whether the decision maker was right in holding that Article 8 was not engaged at all. The question is whether there was a refusal of a human rights claim. Lady, Lords, may I just show you one authority that addresses the circumstances in which an application for leave to remain under one of various categories of the immigration rules could amount to a human rights claim, and I'll then show you the decisions under appeal. So that is the judgment of this court in MY Pakistan. So Milady, my lords, know that there are various categories of the immigration rules. One of many categories is domestic violence. A person makes an application for leave to remain on the basis that they are a victim of domestic violence, and the Secretary of State refuses that application. The issue before the court was whether a refusal of a domestic violence application is actually refusal of a human rights claim. If you go to page 388 of the bundle, Lady, my lords, will see a heading, decision and conclusions. There is a reference by Lord Justice Underhill to section 1131 at paragraph 40. But may I ask you to look at paragraph 41?
So you just see what the facts are in this case.
Yes, so
National Pakistan applied for indefinitely to remain in the United Kingdom.
yes,
TV.
on the basis
Was
that,
he in the United Kingdom already?
Yes.
He was in the United Kingdom, okay.
yes. So they applied for indefinite leave to remain on grounds of domestic violence. The Secretary of State refused the application. They are seeking to argue that refusal of that application is effectively refusal of a human rights claim, attracting a right of appeal to the tribunal. And the court is considering whether that is a correct submission as a matter of law. What is said at paragraph 41 is that not every application for leave to remain necessarily involves a claim that removal would be a breach of the applicant's convention right. That would also apply to entry clearance. So in other words, my lady, my lords, if a person makes an application for leave to remain to join their spouse in the United Kingdom who is a British citizen, well, by default, that is a human rights application. And refusal of that application would be a refusal of a human rights claim. But that is not true for every single category. You'll see the example that is given of applications made under the points-based system. A person makes an application for leave to remain as a student, as a skilled migrant, as a business person. If that application is refused, that does not mean that is refusal of a human rights claim too. And that is essentially paragraph 42. But what the Secretary of State can do, even in those applications where human rights is engaged, is to refuse one but not the other. They can say that I'm refusing your application for leave to remain as a domestic violence, but say nothing about Article 8. And in those circumstances, unless the application is of a sort that would necessarily involve a human rights claim, there would be no right of appeal. Paragraph 44 is the conclusion that an application for indefinite leave to remain as a domestic violence, which one would have expected to have a closer link with human rights, did not inherently involve a human rights claim within the meaning of section 1131. And refusal of that application did not, the court said, necessarily involve refusal of a human rights claim, which is in fact made. So this is the authority that I ask respectfully, Milady and Lords, to bear in mind when you look at the decision as under challenge. Now, in this case, Milady and Lords, there is no dispute between the parties that in one of many letters that FA sent to the entry clearance officer, she raised a human rights claim.
The 17th of May one makes it clear.
Precisely.
First one made Article 8 claims about whether she should be able to go to Egypt first and get biometric.
Indeed.
But by the 17th of May, it was
Yes.
clear she was saying, I need to be with my daughter, and to refuse that
Yes.
would be a breach of Article 8. You
Indeed.
accept she made an Article 8 claim.
So what I accept, my lord, is that she expressly said in a correspondence that she is seeking to rely on Article 8.
In her visa, she cross-referred to a letter from Bymans, which was the pre-action protocol letter, but then there was further correspondence. So there's a sense in which the application cross-refers to it.
Indeed. So she expressed it. So this sort of takes us back to the question that Milady, my lords, asked at the outset. Well, what if a person who has no viable claim at all says in an application that, well, I rely on Article 8? Is that enough to engage?
And you say no.
Well, but yes. I mean, that is the submission that I make, but I do.
Can we go back to the policy for a minute, just to have a look and work it through? We go back to tab 24.
Yes.
Just looking at the initial sort of streamlined exercise,
Yes.
page 480.
Yes.
Does the application say that it's a human rights claim? Yes, it does.
Indeed. So the decision maker said that it does.
So you're then into the two, you don't go down to 2, 3 and 4 because we're not dealing with whether it's inherently a human rights claim.
Yes. So you go.
So if yes, but no reasons are given, refuse the claim with no right of appeal.
Yes.
If yes and supporting reasons are given, then proceed to step 3. Well, what was it in this case?
Well, here reasons were given
Yeah.
by FA that refusal to grant her entry clearance would be a breach of human rights. The decision maker answered question 1 in the affirmative, and then moved on to question 3.
Yes.
And the decision maker answered question 3 no.
Said it's not capable of engaging human rights because this is not a case in which refusal could ever be capable of amounting to a disproportionate interference with family life.
Yes, or the decision is not capable of engaging Article 8, so you do not even go to the proportionality stage.
The policy tells the decision maker that there are only 3 relationships that could
Yes.
engage Article 8. This isn't one of them, so end of story.
This is what, yes, the decision maker did. So may I then show you the decision?
I've got major problems, as other members of this court knows, with the words engaging human rights.
Yes.
I've been trying not to say it. I mean, engaging human rights doesn't help. It's interference with human rights.
Indeed.
There are 2 potential reasons why something is not capable as a matter of law of amounting to interference. One, the person is outside the jurisdiction, so Article 1 of the treaty, it doesn't apply.
Yes.
Or Section 8, that which is claimed cannot amount to family life within the convention.
Absolutely.
And the thing is, you've got to take a view on how close the relationship is for that. And I do wonder whether, if you're saying, I'm not satisfied that the relationship is sufficiently close, such that the refusal of an entry clearance is interference with that, if you aren't actually deciding the human rights claim.
That is the issue here.
That's
But
what
this
you're saying here. It's not she's outside the jurisdiction, it's the relationship isn't strong enough to use neutral words.
yes, Lord, the observation is entirely accurate. But may I make this point with respect that this policy is to assist decision makers who are not necessarily lawyers. So the aim is to explain things in a way that is as convenient and easy as possible for the decision makers to apply law. So with that in mind, if you go to the core bundle, you have the decision subject of these proceedings at page 306. This is tab, the last tab, tab H. So the decision of 24th of May 2024. Look at page 307. You'll see that the decision maker essentially summarizes the claim that is made in the letter before claim, pursuant to which there was a reconsideration. And the decision maker comes to a conclusion at page 308 that the requirements of the immigration rules are not met. And I'll come back to that in due course. But consideration of the Article 8 element of the claim is set out in the third paragraph at page 308. And the decision maker said that
I note the letter before claim states that Article 8 is relevant. He says, I am satisfied that your application is not capable of engaging human rights and therefore a human rights claim has not been made. Well, I thought on your own case that's not true because a human rights claim has been made and stage 1 of the guidance, insofar as it's relevant, has been passed. So he's wrong to say a human rights claim has not been made. It has been made, hasn't it?
No.
so the way in my submission the policy works is that if the answer to any of the first three questions is no, then there would not
It's
be a
still not
human
been,
rights
even
claim.
though it's been claimed, it's still not a human rights claim.
That's why the policy doesn't it works the way that it does. I think Mr. Malik's right with respect, because if you actually look, the question at 480 is, has a human rights claim been made?
Yes.
And if the answers are no, it hasn't. And you say, you go through the exercise, it says it's a human rights claim, so you then proceed to, and there are reasons, so you proceed to step 3. Decision maker says matters raised are not capable, whatever that means, of engaging human rights, and therefore refuse the claim with no right of appeal. Therefore, there is no human rights claim.
Indeed. So the problem arises from the way in which question 3 is framed.
Yes.
And the question is whether human rights are capable, whether the application is capable of engaging human rights.
Yeah.
And the decision maker took the view that it wasn't. What the Upper Tribunal essentially said was that, well, this is actually a consideration of stage 1 of the human rights claim, stage 1 of RASGAR, whether there is private or family life. And if there isn't, if the decision maker says there is no private or family life that is engaged by Article 8, then that, the Upper Tribunal said, is the refusal of a human rights claim. But what is really happening here is that the decision maker is considering the prior question.
Yes.
And may I ask you, with respect to see in particular how that paragraph ends. Applying the policy, the decision maker says this decision to refuse your visa application is not a refusal of a human rights claim, and there is no right of appeal against this refusal. The decision maker is saying that, well, I've answered question 3 in the negative, and therefore what I'm refusing is not a refusal of a human rights claim. Now the decision...
If there's a problem with that, then on your analysis, it's an error of law that would be capable of
judicial review.
review.
Indeed, absolutely. So I do not shy away from the fact that there could be a potential problem with the reasons that are given, but the right of appeal is against refusal of a human rights claim, not against answer to the third question.
Yeah, I'm going back to the statute. I don't actually think the policy helps. It may tell people who don't read Section 82
Yes.
refuse a human rights claim. 113 means a claim made by a person to such a state at a place designated that it would be unlawful to refuse entry.
If you read that literally, it would mean however specious and however outlandish the claim, so long as you claim that it engages your human rights, it's a human rights claim, and that can't be right. That can't be what Parliament intended.
But what I'm grappling with is when you start making, well, one, is that what Parliament intended? But two, if on the facts of this case, grappling has occurred, the ECO has sat down and thought, how strong is the relationship? Who is the relationship between? That begins to sound as if a mind is being turned to the elements of the claim.
Yeah.
And then you're saying, well, I don't think this claim satisfies Article 8. And if it doesn't satisfy Article 8, I am not allowing you to enter because I'm satisfied that refusing you entry won't breach Article 8. That does sound like the process of determining a claim. You say not.
That is the issue. I mean, I accept that this is where this is where the line is blurred. But I took you to the policy to explain why the decision maker said what it said.
It said, yes.
Now, Milan friends, I'm sure when they'll make submissions, we'll take you to the parts of the decisions saying that the decisions made below saying that the Secretary of State accepts that there is a claim.
No.
Of course, I accept that there is a claim in the sense that that FA expressly relied on Article 8, gave supporting reasons. But what the decision maker has done here is that has said that I'm not refusing the human rights claim. The decision maker may be right, the decision maker may be wrong, but that is a question for a different court, not for the tribunal.
We're going to turn on the label that the decision maker puts. Don't we actually have to look at the substance of what has happened and decide whether that falls within what Parliament has asked?
Absolutely, yeah. I accept that entirely. So you look at the substance of the decision and you decide whether this is a refusal of human rights claim in the sense Parliament intended. In considering that question, my ladies, my lord, the decision maker will bear in mind two things in particular. The first, the policy that I've taken you to, because the policy assists the decision maker in deciding, in understanding the reasons given by the primary decision maker. And secondly, what the decision maker has said. If the decision maker says that this is not a refusal of a human rights claim, then it would require quite a lot to persuade a tribunal that that isn't the case, and there is in fact a refusal of a human rights claim.
I suppose in theory that could happen if the decision maker said, I'm not refusing a human rights claim, but it was one of the cases that Lord Justice Underhill was referring to in MY,
Yes.
where you've got human rights are inherently engaged in the nature of the decision itself.
Yes.
So it then doesn't matter what the decision maker says, because ultimately it's obvious that human rights are engaged, and they are in fact refusing a human rights claim. The problem here, it seems to me, is this blurring, as you put it, of the dividing line between a situation where the decision taker looks at it and says, well, you're claiming that your human rights are engaged, but they're plainly not, and therefore I'm not dealing with it. Or whether they're saying, well, I've gone actually through step one of Rasgar and I'm refusing it.
Yes, absolutely. Milady is absolutely right with respect on that. Now, one submission that I'll develop when I'll address you on subsequent grounds is concerns the intention of Parliament when the Immigration Act 2014 was enacted. The obvious intention was to abolish appeal rights against a variety of different immigration decisions. So unless, my lady, my lords, there is that dividing line, appeal rights are introduced via back door, in the sense that, take example of a visitor or a student or a points-based system applicant. A person says that, well, I'm relying on my human rights, grant me entry clearance. And the decision maker says that, well, your claim is not capable of engaging Article 8, and that person will get a right of appeal. And then compounded with the problem that I will highlight when I will address you on ground 6, is that the tribunal then decides whether the requirements of the immigration rules are met, whether you're a visitor, whether you're a student, whether you are a business person, etc. So you go back, in my respective submission, to the position where there is a right of appeal effectively against every immigration decision, where a person says, well, I rely on human rights. And that cannot be right. So, well, this essentially is my case on ground 1. This is a question of law for the court. It depends not on the views of, in my respective submission, the First-Tier Tribunal or the Upper Tribunal. If you take the view that the submission that I'm making is correct, that means there isn't jurisdiction. If you decide that, well, this isn't correct, and as a matter of substance, this is a refusal of a human rights claim, then there is a right of appeal. So this, my lady, my lords, is ground 1. So I will move on to grounds 2 and 3. Those grounds relate to the Upper Tribunal's error of law decision. In the authorities bundle, behind tab 2, my lady, my lords, will find section 12 of the Tribunal's Courts and Enforcement Act 2007. And this relates to appeals from the First-Tier Tribunal to the Upper Tribunal. The language of this section is replicated in section 14, which concerns appeals from the Upper Tribunal to this court. So the question, there is a right of appeal against a decision on a point of law. There is no appeal on facts. And you'll see that the Upper Tribunal has a discretion, but not an obligation to set aside the First-Tier Tribunal's decision, which enables it to consider materiality of the error alleged. And if it does, then the options are to remit the case or to remake the decision. The short point is that the appeal is against an error on a point of law. Now, bearing that in mind, in the core bundle, if you go to page 147, you will find the First-Tier Tribunal's decision. It's tab B of the core bundle. Sorry, my apologies, it's tab E.
CFT2.
Tab E. So 147, this is the decision of Judge Bartlett. If you look at the reasoning, you will see from paragraphs 15 to 26, Judge Bartlett concluded that there is no jurisdiction and there is no right of appeal. So what she could have done at 26 is that she could have ended her decision there. But she decided in the alternative to consider the substantive issues. And under the heading substantive case, the judge makes a finding for a variety of reasons which are not relevant for the purposes of the argument that I'm seeking to make, that the requirements of the immigration rules are not met. That conclusion is at paragraph 35. The judge says that I do not accept that the appellant FA would return to Gaza after a short visit. So finding of fact. Well, whether that finding is open to the tribunal or not, it's a different question, but there is a finding of fact. The judge then considers whether the family life limb of Article 8 is engaged. And for the reasons given at paragraph 38, concludes that family life limb of Article 8 is not engaged. So 38, I have given consideration to Kugatis and guessing I do not find that Article 8 is engaged in this case for the following reasons. And you then have findings of fact that there is some financial dependency, financial support, but that financial support is not sufficient. The sponsor has depression. She speaks to her mother regularly. There is an element of emotional support. That's not enough. FA has lived her life in a separate country from the sponsor for 18 years. So they've been living apart from 18 years. And for those reasons, there is no protected family life. Judge could have ended her decision there, but she then makes an alternative decision. In the further alternative, the judge says at 39 that in case I was wrong and family life was engaged, I have considered other parts of the Rasgar test. This is proportionality, and the judge finds that any interference would be proportionate.
The actual decision, though, under the words notice of decision, is the appeal is dismissed for want of jurisdiction. So I do wonder if she had no jurisdiction. It's very kind of her to have done this for everyone. But what's the status, before we get on to what the powers of the Upper Tribunal was, what was the status of the things that you described in part as findings of fact and in part as decisions or alternative decisions on bits of Article 8? Are those, do they stand or fall if the decision for want of jurisdiction is set aside?
My submission is that they stand. And that was the reason why the judge was making those findings. That in the event there is a challenge, an appeal against that decision, the judge was making alternative findings.
Well, I can understand how that might work if it was found that she did have jurisdiction. So if contrary to her original views, she did have jurisdiction, then she's gone on and decided what she would have decided if she had jurisdiction, and
Yes.
therefore that's binding, you say.
Yes.
But if she didn't have jurisdiction, she didn't have jurisdiction, and that's the end of it.
Well, indeed. So, I mean, one way to test the argument would be to consider how this court could or would approach 8 grounds of appeal. Now, if you are with me on ground 1, that is the end of the appeal, and there would be no need for the court to say anything on grounds 2 to 7. But if you decide that I'm right on ground 1, but you decide to say something on grounds 2 to 6, you are in principle entitled to say that, in the sense that if you're wrong on...
It would all be open to subject to it going further.
Yes.
But the purpose of the discussion here is we're going to get on in a minute to the Upper Tribunal. And what I'm interested in is why is the Upper Tribunal compelled to accept these findings? and when could they depart from the findings?
Yes.
And I'm looking partly at what are the status of these things from paragraph 26 or whatever it is onwards. And secondly, even if they are in some way findings, what then would be the powers of the Upper Tribunal to say, well, you've got the basic jurisdiction, you've done this, but we are going to exercise the jurisdiction now. So it's two things really. What's the status of the findings, statements, and then secondly, to what extent is the Upper Tribunal bound generally, or in this case, by those? That's what I'm not generally unclear about.
The way I respectfully put the case is that, well, for present purposes, there were three questions before the tribunal. The tribunal answered all three questions. First about jurisdiction, the second engagement of Article 8, and third proportionality. The Upper Tribunal took the view that the judge was wrong on question 1. My submission is that the judge's findings on questions 2 and 3 stand. The Upper Tribunal is not bound by them in the sense that the Upper Tribunal can interfere with those findings if the Upper Tribunal concludes that those findings are wrong in law.
Is that because of some provision of the Courts Act 2007, or and they've got, say for example, they sometimes preserve findings.
Yes.
So it might be helpful to take us to the rules or the statutory provisions that deal with the powers of the Upper Tribunal, and then with the actual decision of the Upper Tribunal.
So that is section 12. So the Upper Tribunal, the provision that I've taken you to, the Upper Tribunal has a power, not an obligation, to set aside the First-Tier Tribunal's decision if there is an error of law. So the Upper Tribunal may, section 12(2) says, set aside, but need not to set aside the decision. That empowers, in my submission, the tribunal to consider, the Upper Tribunal to consider whether the error alleged is material to the outcome, whether other findings should be preserved. Not very different from the way this court exercises appellate jurisdiction. Take example of a protection claim and a human rights claim. A person was unsuccessful on protection claims below, but was successful on human rights grounds. There is an appeal to this court. This court says that well, the decision as to the human rights claim was wrong, but the refusal of the protection claim stands because there is no error of law in that decision.
The appeal was for the decision of the appeal was for want of jurisdiction. Assume the Upper Tribunal was correct to set that aside. They haven't made an error of law. That's the decision they set aside. And if they set it aside, they can either remit or they can remake. And I'm wondering what's the prohibition on them remaking it and starting afresh?
There is no prohibition in the statute. They have a discretion.
I've just looked again. I've just reminded myself of what they did at 146. They set aside the FTT decision in its entirety with no findings preserved.
So,
and therefore, that decision has gone as a result of the Upper Tribunal's ruling.
Yeah.
And then they remade it for themselves. So really, that's the end of that.
Yes, so I don't think they were bound, and I don't think you can show that there was an error of law on their part.
I'm not submitting, my lord, my ladies, my lord, that they were bound by the alternative findings made below. I accept that they had a discretion whether to set aside the decision in its entirety or whether to preserve those alternative findings. I accept that they had a discretion. My two grounds are directed to the way that discretion is exercised. They gave no adequate reasons as to why they were interfering with the alternative conclusions.
Why did they need to? I mean, once they've found there's an error of law, they can set it aside. End of. That's what they do all the time, day in, day out. the Upper Tribunal finds that the First-Tier Tribunal had an error of law. They then look to see whether or not to preserve any of the fact findings to save having to do it all over again themselves. If they decide not to do that, they just set it aside in its entirety. But you don't normally see, or at least I certainly don't regularly see, a section in the Upper Tribunal decision which explains why they're setting aside the first tier.
Lady, take example of a case where a person makes an asylum claim to the Secretary of State. A judge dismisses the asylum appeal, but allows the human rights appeal. There is an appeal to the Upper Tribunal against the decision to allow the human rights appeal. The Upper Tribunal concludes that the decision to allow the human rights appeal was wrong in law. The Upper Tribunal has a discretion whether to set aside the decision completely or to set aside only the decision that concerns the human rights claim and to preserve the decision as to the protection claim.
Well, given that there was no appeal against the protection claim, the chances are that it wouldn't interfere with it.
Indeed, but the real reason why they wouldn't interfere with it, in my submission, is because that alternative decision is free from any legal error.
Well, can we look then at page 110? Because this seems to be the problem now. You're not saying that they have to follow it. They should have followed it. And if you look at paragraph 61 to 63, you've got their reasons. You were saying, look, it doesn't make a language difference, so it's not a material error. Mr. Churko was saying, well, it might have made an error. You know, she's found there's no jurisdiction because she's got a view about Article 8. And then when she goes on and deal with Article 8, not surprisingly, the view about jurisdiction is impacting on the view on is Article 8 applicable. And they say they've carefully considered it and so on. And they decide the safer, better course of action is to set it aside in its entirety with no point preserved. And I think you'd have to show that that was a decision that no reasonable tribunal could possibly come to, don't you?
Yes.
Is that your claim?
That is, the submission is that at 63, paragraph 63, the Upper Tribunal has well, either not asked itself the correct question or made a decision that is not adequately reasoned. The question that, in my submission, the tribunal should have asked itself was whether the alternative conclusions are vitiated by an error of law.
And they say they might be. And because of that, they're going to remake it. And where's the error there?
Well, the question in my submission is whether the alternative conclusions are vitiated by an error of law, as opposed to whether the error is capable of impacting the outcome of the appeal. That is ground 2, and that is ground 3.
Just before you move on, does this involve focusing on what the decision is in section 12? Because the trigger is a finding that the making of the decision concerned involved the making of an error of law.
Yeah.
And then the discretion arises. And the discretion is to set aside or not, to remit or remake the decision. If the decision involves the bit of, well, the one that we can see that was actually the decision, then there wouldn't be a power to set aside the alternative conclusions because they're not part of the decision.
So the decision I accept is the decision read as a whole, the ultimate decision to dismiss the appeal for want of jurisdiction. If that decision is wrong in law, the Upper Tribunal has a discretion to set aside the decision in its entirety. My grounds 2 and 3 are that in exercising that discretion, the tribunal asked itself the wrong question. If there was no error of law in the alternative conclusions, then the Upper Tribunal should have exercised that its discretion to maintain those findings. So I'll move on to grounds 4 and 5. Those grounds concern engagement of Article 8, the family life limb and private life limb, and the Upper Tribunal's remade decision. Of course, I advance those grounds assuming that my lords will reject everything that I've said so far. So may I address you first on law and then on the reasoning that the Upper Tribunal gave. The law is now, in my submission, conclusively, if not authoritatively, set out in the judgment of this court in IA and others. And that is tab 23 of the bundle. Now, as Lady Lords, of course, I have limited time to make my submissions. What I will do is that I will show you all relevant parts of IA, even those parts that are relevant to my other grounds
Yes.
6 to 8. So the court has, of course, read the judgment. The court knows the basic facts from paragraph 2. Family lives in Gaza. They apply to come to the UK to join a relative, a sponsor, who is the brother of the principal applicant, and they were successful in the tribunals. A succinct summary of the court's conclusion is set out at paragraphs 10 to 12. So paragraph 9 says, well, we have decided to allow the appeal, and our reasons can be summarized here. The first reason is paragraph 10. What is the test of engagement of the family life limb of Article 8? Well, the family life limb of Article 8 is normally limited to co-family, those who are living together, and there will be no family life between parents and adult children or adult siblings unless they can demonstrate, this is the test, additional elements of dependence involving more than normal emotional ties. The court then, and this was the real issue in the appeal, says that the test of real, effective, and committed sport is different. This is the last sentence of that paragraph. The real, effective, or committed sport test is lower than the additional elements of dependency test. And applying that test, the court found that Article 8 was not engaged. The second point is made at paragraph 11, which is that when it comes to proportionality assessment, the court or tribunal is looking primarily at the Article 8 rights of those who are in the jurisdiction of Article 1 of the Convention, the sponsor. So those who are not within the jurisdiction, their rights are not engaged. They do not have sort of freestanding rights as such, and their rights are engaged through the sponsor who is in the UK, who falls within the jurisdiction. The third point, paragraph 12, in assessing the question of proportionality, the real question is whether very exceptional or compelling circumstances have been shown. Even if family life existed, the question is, just against letter F, very exceptional or compelling circumstances have been shown. The tribunal was wrong to pay so little regard to immigration control policies of the Secretary of State. The tribunal overstated the importance of the family's short-lived family life with a sponsor, if it existed, and the welfare of the children.
Yeah, very exceptional or compelling circumstances was an issue, presumably, because that's the provision which said when they should be allowed to come in. Here, it's a slightly different situation. The first question is whether she met the medical visitors test. And there's your point about who decides that.
Indeed.
Very compelling circumstances isn't a general thing. That was for that particular case. But
Yes.
what you want us to draw on is the reference to we must remember the importance of government decision making.
Indeed. Absolutely, yes.
Okay.
No issue with that. Now, if you then go to page 448, you will see a heading just above paragraph 38. The authority is relevant to Article 8.1, and under that heading, the court reconciles all previous authorities. But for present purposes, may I respectfully take you to page 452. And so 452 is effectively a quote from the judgment of the Strasbourg Court in Kumari. And may I ask you to look in particular at paragraphs 38 and 39 of that quote, which you have at page 452. So this is where the Strasbourg Court is giving examples. They are nothing more than examples, but the court has said that they are helpful. So in cases where adults have physical or mental disability or illness of sufficient seriousness and were in need of constant care and support, the court has accepted such dependency. Is there a physical and mental disability, and whether the applicant is in need of constant care and support? 39, conversely, in cases concerning certain medical conditions, the court has refused to accept that the state of health of the applicant and their relative is serious enough, or even if sufficiently serious, was sufficient in itself to warrant a finding of existence of dependency. And you'll see the examples are diabetes, heart condition, and so on, including schizophrenia, paranoid schizophrenia, which is very serious, but did not meet the test, in the sense that it did not show that the applicant was compelled to rely on the family care. So these are the examples. I'll show you a paragraph where the court said, well, these are merely examples, but are helpful in deciding whether Article 8 is engaged. Paragraph 60, page 405, it is clear in our judgment, the court said, from the review of these authorities, the consistent jurisprudence of the Strasbourg Court, that the test is additional elements of dependency involving more than normal emotional ties. The court then considers the judgment in Kugatas, which of course gave rise to the controversy that was an issue before the court. In Kugatas, it was sort of arguably suggested that the test is real effective sport. And if you, after considering Kugatas together with all other authorities, the conclusion reached is at paragraph 82, that the actual test, the court again explains, is additional elements of dependency test. At no stage, the subsequent case law said that the test should be real, committed, or effective sport. So from this discussion, we know for sure that the test is not real, effective, or committed sport. So this is all what the court said about engagement of family life limb of Article 8. If you then go to page 460, just against letter E, you'll see a heading Abbas. And may I ask you to look at paragraph 97. This is where the court deals with the question of whether there is positive or negative obligation. And the positive obligation, this is the quote at paragraph 97, rests in large part on the fact that one family member is already in the contracting states. And a valid point that is made that any expansion would essentially create an unlimited obligation on the contracting state to allow entry to an individual who might be at real risk of ill treatment contrary to Article 3, regardless of where in the world that individual might find himself. So Article 8 is engaged not by reference to suffering of an applicant abroad or their circumstances, though they might deserve utmost sympathy and compassion. It is engaged by reference to the rights of the person who is in the UK. And the conclusion of that discussion by reference to Abbas and all other cases is at paragraph 100. It is in principle open to a person who is outside the jurisdiction to rely on Article 8, but they will have no right of their own under Article 8.
If you change the facts slightly, say the mother came on a visit or actually was given medical permission, and whilst here during the currency of the visa had a catastrophic stroke and couldn't go back, then you might say, well, yes, Article 8 applies there, but you would say that's because she came in and things happened. But when you're outside, it's different.
So that is Article 1 of the Convention. So in that case, the applicant would be in the
Established a
UK,
family life here.
whether as a visitor or whether on any other category. Her rights would be fully engaged. The question would be whether to remove her would be a disproportionate interference with her rights, but she has no right, if she's not in the jurisdiction of the country, to expand Article 8, as the court said, would then mean that every person, no matter where they live, will have an Article 8 right. There's no positive obligation to admit every member of the fighter family of the person within the territory. So the focus must be on the rights of the person who is in the UK. Now then, next page 464. This is where the court is now sort of summarizing the conclusions again. There is a heading just above paragraph 116, the correct test to be applied to determine if there is family life. And you will see 4 points that are made. Summary appears earlier in the judgment.
Sorry, what's the page?
Page 464.
Thank you.
Paragraph 117, the domestic courts have accepted to follow the consistent jurisprudence of the Strasbourg Court. And paragraph 119, the test is whether there are additional elements of dependency. And then paragraph 112, the real, committed, and effective sport test is different from the additional elements of dependency test. And examples are then given in the next few paragraphs. So I, in the course of my submissions earlier, took you to the examples in Kumari where person has a mental or physical disability that require constant care. If you look at paragraph 125, you'll see that the court said that dependence is more than existence of sport. And Kumari makes it clear that it's harder for adults to demonstrate necessary dependency. Examples in Kumari, the examples that I've taken you to, make it clear the kind of physical and mental dependency that might qualify. They are not exhaustive. Dependency may take many forms, but Kumari reminds us, the court said, how stringent the test is. Now, why is it that the tribunal's decision is set aside? That is at paragraph 128. the error on part of the Upper Tribunal was that they had referred to real, committed, and effective sport test mentioned in Kugathas. In my submission, the same error the tribunal made here, and that was a different test. That was the first error the tribunal made. The second error, this is paragraph 133, is that their focus was not on the family member who was in the UK. The family members had not seen one another for some 17 years. And that was said to be relevant. And finally, paragraph 136 on that point. The court reminds itself that the family life envisaged by Article 8.1 is primarily of the core family normally cohabiting together. So this is sort of fits well with the example that my Lord Justice Lewis gave. Assume that FA comes to the UK, becomes part of the core family unit. They are now cohabiting together. That would be a different case altogether from a case where, as the court said, the relatives have not cohabited for years. Here, 20 years, in this case, good 20 years. Next, just above paragraph 137, the court considers whether the Upper Tribunal was right to accord weight to Article 8 rights of the family, in addition to those of the sponsor. There was a conflict of authority at the Upper Tribunal level. This is paragraph 139, the judgment in Al-Hassan. This is the Upper Tribunal's judgment is inconsistent with KF Syria. And the conclusion of all that discussion is at paragraph 142. Even if family life had existed between the sponsor and the relatives, that would not have meant that Article 8 rights of the brother or family outside the UK were meant to be the main focus of the proportionality exercise. Focus ought to be on the family member who is in the UK. Paragraph 144, in that case, the Upper Tribunal unhelpfully, the court said, relied on the Upper Tribunal's authorities, KF and Al-Hassan. And if you look at the next page, page 469, you'll see that the tribunal was wrong. The court said to place reliance on Article 8 rights of the entire family. And of course, there was an additional element concerning welfare of the children.
Sorry, which paragraph?
So paragraph 144, the way that paragraph ends. So as I respectfully emphasize, this is a case where the appellant and the sponsor have not lived together for a good 20 years. If you look at page 470, paragraph 151, between letters D and E, it was relevant, the court said, that the family had not cohabited after the Gaza conflict began.
I can read the rest of the sentence.
Yeah, and you'll see what is said there, and then the conclusion at 152 that the Upper Tribunal attached the wrong weight to the development of the family life in future. So the question isn't about sort of developing of a family life in future, but whether the interference with the existing family life, if there is any, is proportionate. There is then a discussion as to the proportionality, the question of proportionality. And if you look at paragraph 158, page 471, the court refers to ECHR. This court is of course familiar with section 117B, which the Upper Tribunal in this case did not consider at all. But that section sets out matters that the tribunals are required to consider. The government's policy deserves due weight. It's paragraph 159 and 160. Why due weight was not given in that case. An example is given that if the Secretary of State had a policy, a resettlement policy concerning Gaza, the position would have been different. Just finally, in this judgment, if you go to page 473, 166, though the tribunal said that it was placing considerable weight to the immigration rules, it failed to do so in substance. The Upper Tribunal attached the wrong weight. There were no very exceptional or compelling circumstances. And the court substituted a decision that the interference with the Article 8 right, if it is engaged, is proportionate. So this really is IA. In my submission, it sets out the law authoritatively that applies to this case. Now this, in our case, concerns a visit visa application. And there are two further authorities that are relevant in relation to visit visas. And they make additional points that are additional to IA that are relevant to my grounds 4 and 5. So may I just quickly show you those two authorities. So first is the judgment of this court in Kupi. You have that behind tab 14 of the bundle. The facts are summarized at paragraph 1. The person makes an application for entry clearance to visit members of their family in the UK. The respondent refused the application on the basis that they were not a genuine visitor. And they refuse the human rights claim, and there is an appeal to the tribunal. The tribunals allowed the appeal, and the entry clearance officer brings an appeal to this court, essentially on the ground that Article 8 was not engaged because it was a visit visa application. So if you go to page 281, you'll see a heading discussion, and there is then a discussion of various authorities. Most, if not all, of those authorities were considered in IA and others. But the reason why I show you this authority is at paragraph 30, which is page 285. So one consideration that applies in addition to a visit visa case concerns the shortness of the proposed visit. If an applicant abroad says that, well, I want to go to the UK permanently, position would be different. But the shortness of the proposed visit, the court said, was yet a further indication that the refusal of leave to enter did not involve any want of respect for anyone's family life for the purpose of Article 8. A 3-week visit would not involve significant contribution to family life in the sense in which the term is used in Article 8 cases. Shortness of the proposed visit. A short visit will not establish relationship between the individual concerned, even if there is a positive obligation. So this is Kopi. The next authority, the final authority.
It's going to be in due course that it's the same here. She's coming for up to 6 months. She wasn't coming to have a family life. It wouldn't actually matter whether her daughter was here or not. Yes. What she was coming for was the medical treatment in Cromwell.
Indeed. So that was yet a further indication why Article 8 was not engaged. there was nothing that was that merited respect for anyone's family life. Next, if you go to tab 13, you have the judgment of this court in Honorel. The facts are summarized at paragraph 2,
Sorry, which tab?
tab 13. So a person who resides abroad makes an application for a visit visa to visit their brother in the UK, short visit for 4 weeks. They say that Article 8 is engaged, and the appeal under Article 8 is allowed, and the entry clearance officer brings an appeal to this court on the basis that Article 8 was not engaged. If you look at page 269, this is judgment of Lord Justice Singh, you'll see a heading, right to respect for family life. Under that heading, Lord Justice Singh again refers to the key authorities on the subject, and then comes to a conclusion at paragraph 35, which is relevant for our purposes. First, as a matter of principle, the question of whether there is family life is a logically prior question and cannot depend on the purpose for which an application for entry clearance is made. And secondly, the shortness of the proposed visit, if anything, is an indication that refusal did not involve any want of respect for family life for the purpose of Article 8. Shortness of the family visit is relevant and would indicate that the refusal did not involve want of respect for anyone's family life. And so these are the 3 authorities that I respectfully invite you to bear in mind when you consider the Upper Tribunal's decision. May I take you to that decision now? It's page 112, the Upper Tribunal's remade decision, page 112 of the court under tab B. So if you go to page 114, you'll see heading the law. The Upper Tribunal summarizes what it considered to be law under the heading family life between adult family members. So after considering various authorities, the Upper Tribunal self-directed itself as to law at paragraph 16, makes 3 points. All 3 points in my submission are fundamentally flawed. They are wrong in law. The first point is that
They're applying Kagathas and not.
precisely. So as can be seen, the test, not our test, but the
The
test
test
is whether there is effective or real or committed sport.
isn't.
So that is wrong in law. The second point after the comma is that there is no real distinction between the positive obligation and the negative obligation. But there is,
There is, plainly.
as the case law tells us. So the second conclusion is fundamentally flawed, and so is the third conclusion. The third conclusion is even more striking. The question is whether fair balance has been struck. That is not the question. This is the prior question that is being considered, whether Article 8 is engaged at all. So at that stage, there is no question of fair balance. And in my submission, paragraph 16 is indefensible. It is fundamentally flawed, it is wrong in law, and it infected the assessment that is made.
I suppose you submit that although at 15b in the previous page, they do say the question whether additional elements of dependency exist. When you get to 16, drawing the threads together, they see that as a synonym for effective reports, although they've used the words, they're using them in a different way from the way that this court reads them in IA.
That has,
Presumably say 107 makes that clear.
so same error that the tribunal made. Now, if you then go to paragraph 28, this is where the tribunal sets out the policy that I've taken you to. And the tribunal says that, well, this policy is at odds with the relevant principles. Well, first, question as to whether the policy is or isn't at odds with respect is not a question for the tribunal. When the tribunal is sitting in appellate jurisdiction, at least not supervisory jurisdiction. But second, the conclusion reached is wrong. This part of the policy is not at odds with the principle in the case law. It is, in my submission, consistent with the principles in the three authorities that I've taken you to.
It might be wrong to say the only relationships. I mean, you can conceive circumstances.
Well, my respectful submission is that no matter how hard one thinks, one cannot, in my submission, conceive circumstances where Article 8 would be engaged in a visit visa context. In a different context, it might be engaged, but in a visit visa context.
Because of the shortness of the visit.
Because of the shortness of the visit, precisely, yes.
So the words in the policy that are critical for this purpose are in visit
Visa applications,
Yes.
yes.
Yes,
It's clearly not valid as a general proposition. The authority say that
absolutely. Yeah.
however high you put the test,
It's
there
not.
are cases where an adult child can be so dependent or adult
Yes,
parent can be so dependent. on
Absolutely.
family life.
absolutely. That precisely is the reason why I took you to Kopi and Honorary. If a person makes an application to join a family member who is not a spouse, parent, or a minor child, the position is different, but in Article 8 context, those are the three relationships where visit visa is capable of engaging Article 8. But I do respectfully emphasize that even in those cases, the starting point is that Article 8 is not engaged when a visit visa application is refused.
You could imagine, if you want to have hypothetical examples, a grandparent, 2-year-old child, poor mother killed in a car crash, father's a ne'er-do-well and disappeared, and the grandmother says, for goodness sake, let me come and look after the baby. And still not engaged, is it, in your words? Still doesn't apply. No, she stays where she is and the baby starves to death.
So if she says that, well, allow me to come to look after the baby, then she's not seeking entry as a visitor.
No, she's coming for 6 months to sort things out. She really wants to visit. She doesn't want to stay in this
I see.
country. She's hoping she may be able to persuade a relative and so on. She said, let me come for 6 months. Don't let the baby suffer. And so the word is only is wrong, because I've just thought of an example.
So in that case,
Actually, in ways that happens quite a lot. Grandparents often do. They must in England as well.
so in that context, Lord, I entirely accept that it would be desirable to allow that grandparent to come to the UK for 6 months to look after the child. It would be desirable, indeed. But whether it would engage Article 8 in the sense that is referred to in
That may be an issue, but to say couldn't ever, which is what the only said. But anyway, we're not into grandparents.
No.
So
So
be a grandparent as well.
yes, indeed. So again, I mean, there could be a challenge set to this
That's
policy.
the way you said it was a challenge you throw. I said, who can think of an example? So I was thinking of an example.
So,
Pass the time,
yes.
but don't worry about it.
Milord, yes, I mean, well, it's only Milord who could think of an example in that case. But that is that. Now, you then go to paragraph 37, you'll see a heading oral evidence. You will see that Ms. Pearson, a senior policy manager, gave evidence for the Secretary of State, for the entry clearance officer. I'll show you her witness statement, but a summary appears at that paragraph. The evidence essentially was that the Secretary of State was seriously concerned as to the potential number of applications from war zone, conflict zones. Can I, perhaps it would
This
make
is pre-IA, of course. It was when IA went the other way round, and now this court has said IA was wrong in the Upper Tribunal.
So can I just ask with respect, Lady Lords, to just pause at paragraph 38 and look at a document in the supplementary bundle, because if you first look at that document and then look at paragraph 39, that paragraph would make more sense. So in the supplementary bundle, behind tab B, page 50, you have the witness statement of Laura Pearson for the Secretary of State. And in this, she sets out the very serious problems that would arise from an expansion of Article 8.
But isn't this basically the same sort of floodgates argument that this court looked at in IA?
Yes, so absolutely, but there is a sort of different reason I'm showing you this statement, and that reason is at paragraph 5.
Right.
So paragraph 5, final sentence, she says,
Yes.
the government's judgment as to the appropriate balance of these public interest concerns is reflected in the immigration rules. And this will be relevant to my final ground, but I deal with it now. So I asked her a question, essentially to the effect that, well, what is meant by immigration rules? Do you mean any category of immigration rule? Or do you mean Appendix FM to the immigration rules? So Appendix FM concerns claims that are based on family relationships. And she said, well, Appendix FM, not every category, but Appendix FM. Appendix FM, this court has looked at on various occasions. At the outset, says that, well, this route is for those who seek leave to enter on the basis of their family life. And this is the Secretary of State's policy that reflects how balance would be struck. My Lord Justice Lewis looked at that part of Appendix FM a few weeks ago. It's not in the bundle. I have copies of Appendix FM if you wish to look at it. But that is the point, that Appendix FM sets out, Appendix FM is the human rights route that sets out the government's view as to how balance is to be struck. And the witness said that categorically before the tribunal. So if I may then take you back to the tribunal's decision to see what the tribunal said about that. So if you look at paragraphs, I've shown you paragraph 38. So if you look at paragraph 39, and if you look at the concluding part of paragraph 39, you'll see on the next page 121, the judge says that, notes that I asked whether she was referring to immigration rules, if she was referring to every category of the immigration rules, or Appendix FM. And she made it clear, Appendix FM. The tribunal said that, well, my question was a leading question. Now, I don't cross-examine
They wouldn't know what a leading question
routinely,
was.
but I, with respect, do not see how that question
Plainly not.
is a leading question.
Doesn't beg the answer.
Precisely.
Where are we getting to with this submission? Because of course we're not in Appendix FM. On her case,
Yeah.
she says, no, I'm not coming to live here. I don't want to live here, I want to go back to Gaza. And there's a different rule for that.
Absolutely. So entirely valid question. It's just that I was making the point now, because I will make a submission in due course. The tribunal said that you meet visit visa requirements under the rules, and that answers the public interest. Because the rules reflect how balance is to be struck. submission is that the rules under Appendix FM set out how balance is to be struck, not every single category of the immigration rules.
But generally speaking, as a matter of policy, the rules will reflect government policy as to who should be allowed in and who shouldn't. There may be a residual element of discretion involved. Generally speaking, that's the way in which it works, doesn't it? If you meet the requirements, I mean, with a visitor visa, there's always that extra exercise because the person concerned has got to satisfy the entry clearance officer that they're genuine. So there's that evaluation on top of the tick box and meeting the rules. I agree with that, if that's the point you're making.
Lady, that is the point that I'm making,
Okay.
but I am, I mean, you hear from me in due course. If it is every category of the immigration rules, that then gives rise to very serious problems.
Yes.
Because that then gives the jurisdiction to the tribunal.
Well, that is, I think, the real issue.
Next point, yes.
Who decides
Yes.
whether or not
The requirements of
she
the rules.
intended to leave at the end of 6 months? Is that a decision for the ECO, subject to rationality, or is it a decision for the tribunal ultimately? Not long ago, you were trying to persuade us that discretion and decision for the tribunal, and we were all resistant and Spence saying, surely it can't be right. Because the question we was hinting there was, is the decision of the ECO a breach? Not, should you reach a different decision? Or are you the ones, the Upper Tribunal, to reach a different decision? That's the real issue. Who decides
Who decides?
whether she needs to go back or not?
Lord, I was, of course, expecting that my Lord would say to me, because a few weeks ago I was before you making an argument.
Yes, you for the Home Secretary again today, so yes.
Yes, but
Changed her mind?
no. I mean, given that particular question, which is entirely fair, may I just hand up an extract from Appendix FM to the immigration rules? Just I showed you that, Lord, in the case of Spence, that Lord you had in mind.
Where would you like us to put this, Mr. Malik?
Well, if possible, perhaps behind tab 3.
Thank you.
There you have the relevant rules. Of course, Lady Justice Andrew and my Lord wouldn't know about the case of Spence that was being argued, but so this is Appendix FM. Sorry. So Spence is a case, I say this essentially for the benefit of my learned friend and other members of the court, was where the Secretary of State the entry clearance officer had refused an Appendix FM application on the basis.
Coming to join his wife and child.
So they refused Appendix FM application, and the question was who decides whether Appendix FM requirements are met.
My lord, the question was who decides whether it's conducive to the public good, which is not the same as whether an individual will return. I'm sorry, but if a case that's not before us is going to be summarised, can it be summarised accurately?
No. So the conducive provision is part of Appendix FM. So the question is who decide whether Appendix FM requirements are met.
There they have to decide whether or not somebody who had done a criminal offence for sexual intercourse with a child and had formed a relationship and ultimately married, just formed a relationship with the child, whether that was conducive to the public good.
Yes.
The tribunal ultimately went wrong, so it was illogical. It said we're not sure that he's given up his interest in girls, but nonetheless we have discretion and we decide. That's not something that's not conducive to the public good. And the Secretary of State was saying the discretion was for the tribunal, and just saying with horror that can't be right. The discretion of what amounts to in the public good, or here intention to go back to Gaza after she's had
For the Secretary of State.
is for the Secretary of State, not the Upper Tribunal.
Plainly for
Or is it?
No, may I then perhaps give an example that is sort of more closely related to Appendix FM. So say a person seeks to enter the UK to join their spouse. The Secretary of State says that there is no genuine and subsisting relationship, and therefore the requirements of Appendix FM are not met. So who decides whether those requirements are met in an
That's
Article 8
factual.
case?
That's a factual inquiry.
Yes.
So I'm not sure that's necessarily a very helpful analogy, because if you're dealing with questions of fact on the evidence, then the tribunal probably would end up making the fact findings. But when it comes to the question of policy or whether somebody actually meets the rules, it's usually down to the Secretary of State.
And it's whether that decision is unlawful. If you want to quash that decision, you have to go for judicial review.
Well,
You don't have the tribunal say, well, on balance, we don't mind child molesters too much, so we will let a few of them in, what the argument was.
well, the problem with that analysis, with respect is very tempting and seems entirely correct. Is a judgment of this court in a case called TZ Pakistan. I'll take you to that judgment because I have to deal with it head on, which suggests that the tribunal decides whether or not the requirements of the rules are met. And that judgment is binding, and I will seek to distinguish it and explain why Article 8 rules are different from non-Article 8 rules. But may I just with respect, just go back to the Upper Tribunal's decision, just to close off submissions on grounds 4 and 5, and then I'll move on to the next ground. So we were at paragraph 39, where there is a point about the decision. If you then go to page 127, you see a heading, visit visa applications for family life. And there, the tribunal rejects the submission that I made that Article 8 is not engaged when a visit visa application is made. And the tribunal sort of picked one sentence from the judgment of Lord Singh and said that, well, it does not, the question of whether Article 8 is engaged does not depend on the type of the application that is made. Well, true, Lord Justice Singh made that observation, but immediately after that said that, well, shortness of the visit tells us otherwise. So the conclusion at 96 in my submission is wrong. The fact that an application is an application for a visit visa is relevant. And indeed, in my submission, could be determinative. So that paragraph is wrong. Paragraph 96 and 97. This is where the Upper Tribunal considers private life of the sponsor. This, with respect, was the tribunal's way around the jurisdictional problem under Article 1 of the Convention. The tribunal says that, well, sponsor has mental health issues. There is evidence that, unchallenged evidence, that her mental health would improve if the mother is permitted to join her for a long visit to receive medical treatment. Of course, it's all good for different family members to see each other. That would include them meeting in the country, and that indeed would or could in principle improve the sponsor's mental health. But what the tribunal is there saying is that, well, that means that the private life limb of Article 8 is equally engaged. And if
that's right, you've got to give somebody anything they need that will make their life better.
Precisely, and that cuts across directly the jurisprudence that I've taken you to, in particular Abbas.
Well, it's an illustration of my Lord's point about the unhelpful way of using the word engage in different senses. Here, all that's being said is, well, the question posed is, does the sponsor have a private life?
Yeah.
Well, that's the first question. In that sense, it's something to do with Article 8. The next question would be whether there's an interference.
So, if a parent is in a conflict zone, facing very difficult circumstances. The family in the UK, for obvious reasons, would be distressed. And it's uncontroversial that allowing the family members to meet would help. But to say that if you allow the family member abroad to come to the UK because that would be good for the person who is in the UK, and private life limb is engaged for that reason, in my submission, you defeat the reasoning in Abbas, which says that, and the scheme of the territorial scheme of the convention under Article 1 of the convention.
So it might be said the purpose of Article 1 is to guarantee the right to respect for private life, and there shouldn't be an interference by the public authority with that. Her life and her private life in the United Kingdom will continue. She will see her friends, she will have her relationships as she wishes. What is interfering with that is the fact that her mother is in dire circumstances because of the conflict in Gaza. Yes, it would be alleviated if all sorts of things happen. It might be if she could see her mother and know she was all right, if her mother could come and have the treatment. But that's not this country, this state interfering with her private life in the United Kingdom.
Yes, indeed.
It might be said.
Indeed, and if it does, then, well, with respect, that would then have sort of very serious implications, as were highlighted in Abbas, that every family member who is in a conflict zone with a family member in the UK who are stressed about their well-being would be able to make an Article 8 claim, and Article 8 would be engaged, and we are then in proportionality territory because private life limb is engaged. So that means that the family life limb matters not because private life limb is engaged and you are in the territory of proportionality.
It has nothing to do with it. I might be very upset that a good friend, a pen pal, is in the middle of a war zone, and if it's impacting on my mental health, on this analysis, there's an interference in my Article 8.1 private life. It's not even limited to family members.
Yes. Yes. So paragraph 98 is therefore wrong in law. Then there is a question: do the sponsor and appellant have family protected by Article 8? So this is where the tribunal is considering the family life limb, there are findings. There's no appeal from findings of fact, of course, that, well, they haven't lived together for good 20 years. Paragraph 140, they provide mutual emotional support, they speak to each other, it's quite natural. During the 20 years or 18 years, the sponsor lived in this country, but there were 2 visits to Turkey when they were able to meet. But for present purposes, the conclusion is at paragraph 107, taking into account the evidence in the round, take no issue with the findings of fact or the evidence, we are satisfied that the relationship exceeds normal emotional ties and there is effective, real, committed support between them. So the tribunal applies the test that it identified. The testing is wrong. The conclusion is that there is evidence of close personal ties. That isn't the test. The test is additional elements of dependency in Kumari's sense, and therefore the conclusion is wrong.
If that's right, what do we do next? Do we send it back, or have we got all the facts and remake it, or what's your submission on disposal?
Well, my submission is that the court should adopt the approach that was adopted in IA. I take no issue with the findings that are made, as the court in IA did not take any issue with those findings.
There's no other findings left to be got out. Everything's there.
Everything is there.
The facts are actually agreed. It's the assessment you make of them, you say. Yeah.
I see, yeah. And as the court in IA did, this is the question: if you take the view that that there is an error of law, then decide for yourself whether Article 8 is engaged. If it's not engaged, then that is the end of the end of the matter. Well, assuming, of course, that you reject my submission, that it is capable of engaging Article 8. Of course, if you decide that it isn't, then that it's not even capable of engaging, then that is the end of the matter. Paragraph 109, the judge says, well, sponsor is physically unable to visit her mother in Gaza, obviously, because going to Gaza wasn't possible. A submission that I will make, well, if, simply foreshadowing this, the submission that I will make in due course, so the sponsor cannot go to Gaza. The submission, FA then seeks to persuade the tribunal that, well, when FA will come here, she will return to Gaza after a short visit. But nowhere in these paragraphs, which in my submission reflect an error of law, the shortness of the proposed visit is properly considered. So these are my submissions on grounds 4 and 5. The tribunal was wrong to find that Article 8 was engaged. Ground 6, which is the role of the tribunal. And who decides whether the requirements of the rules are met? And at paragraph 111, the Upper Tribunal rejects the submission that I made that, well, the relevant rules are adult dependent. Valid rules. In fact, I mean, the Upper Tribunal seems to have misunderstood the point that I'm seeking to make. All I was saying was that the Secretary of State has a policy relating to the circumstances in which different family members are allowed to come to the UK on the basis of Article 8.
But if you're looking at medical visits, who decides whether or not somebody is coming for a medical visit? Because if she is coming for a medical visit, the argument is refusing her to come would, assuming Article 8 is applicable, it wouldn't be a legitimate aim because the government doesn't want to stop people coming for medical treatment.
So
the question is, who decides what she is going to do at the end, or what she intends to do?
So the authority that is cited against me is TZ Pakistan, and the tribunal relied on that authority to say that the tribunal decides whether the requirements of the rules are met. And I must, of course.
Isn't that Article 8 outside the rules? TZ Pakistan.
Well, it is Article 8 inside the rules and outside
the
rules.
rules.
And well, that is an authority that I must distinguish in order to persuade
So
you.
is your first submission that it is the Secretary of State who decides, or the entry clearance officer here, who decides whether or not she intends, whether she complies with the rules because she intends to go back or stay?
That is my submission. That is ground 6.
Yeah.
And you want to distinguish
So,
TZ?
TZ, which suggests that the tribunal decides whether the requirements of the rules are met. So TZ is.
Well, let's just pause there before. Why aren't we comparing apples and pears? I mean, the question of whether she intends to go back or stay is whether or not she is a genuine visitor, which to an extent is part of the requirements of the rules, but it's also part of the policy, and that's an evaluative assessment which has to be carried out by the entry clearance officer.
Yeah.
At the moment, it doesn't seem to me that that's got anything to do with whether somebody meets the requirements of Article 8.
That is my submission. Well, that is my submission under
For
ground
myself,
6.
I'll see what Mr. Chirico says about it, but it's nothing to do with Article 8.
So that is how I distinguish TZ. The TZ is about an Article 8 rule.
Well, TZ, as far as I you better take us to it.
Take us through TZ,
Yes, so
I think.
TZ. Yes, so TZ is tab 17 of the bundle. So you'll see from paragraph 1 the basic background facts that 2 applicants made applications for leave to remain on the basis of relationships with British citizen.
Established when their immigration status was precarious, wasn't it?
Yes,
Yeah.
yes indeed. But they were relying on their relationship with British citizens. They made human rights claims on that basis, and the human rights claims are refused because the requirements of the rules are not met. One of the Appendix FM requirements is whether the couple would face there would be insurmountable obstacles to relocation, and if not, whether there were exceptional circumstances. So these are the sort of basic facts. And within the judgment, there is a question as to sort of who decides whether the Article 8 rules are met. Who decides the question of whether there are very significant, whether there are insurmountable obstacles to relocation under the rules. Now if you go to paragraph 35, paragraph 34 first. That leaves the question of whether the tribunal is required to make a decision on Article 8 requirements within the rules, i.e. whether there are insurmountable obstacles before or in order to make a decision about Article 8 outside the rules. And the policy of the Secretary of State is expressed in the rules, that is not to be ignored. The evaluation of the question of whether there are insurmountable obstacles is a relevant factor, because considerable weight is to be placed on the Secretary of State's policy as reflected in the rules. This is Appendix FM. Accordingly, the tribunal should undertake an evaluation of insurmountable obstacles test within the rules in order to inform an evaluation outside the rules, because that formulates the strength of the public policy in immigration control in the case before it. This, in my submission, is the authority for the proposition that the tribunal decides in an Article 8 appeal whether the requirements of the Article 8 rule are met. Not an authority for the proposition that the tribunal decides whether the requirements in any rule are met. So what is being suggested here is that the tribunal should structure the decision in this way: start by deciding whether the requirements of Appendix FM are met. If they are met, then that answers the public interest question.
Is that all on the basis that ultimately, when you're considering whether the state is in breach of its obligations under the convention, that ultimately convention questions are dealt with by the court or by the tribunal? So you end up doing your own proportionality exercise, but if the convention isn't engaged, then it doesn't seem to me that you're actually dealing with the same situation.
That is a submission. Yes.
I think this is quite difficult, actually. There are different types of things that have to be decided. Because of the statute now, when you deal with foreign criminals, you know certain things have been left to the tribunal to decide, because the statute says the court or tribunal must take account of whether it's technical obstacle. So that's one thing. At the other end of the spectrum, there is, for example, the question of whether allowing a child molester into the United Kingdom would be conducive to the public good, and that's a value judgment. Do you agree with child molesting? Are you worked up about it? And that, you might say, is the policy consideration. You've got interim things like, will she go back? I don't believe you're her partner, because I think that marriage certificate is forged. Who decides that the marriage certificate isn't forged? The tribunal or the entry clearance officer? Who decides whether FA is genuine in her intention to go back, or whether this is a way around the rules and so on? And some questions seem to be left to the tribunal, and some seem to be left to the Secretary of State. And in different cases, you get different submissions. Sometimes tribunals do everything, sometimes they don't do certain things. And I've not yet had an organising principle submission as to how we can decide what is for the Secretary of State and what is for the tribunal. You know, that's just to
So
get that off my chest. You can see my difficulty.
and I see that, and a principled way to put a dividing line is to consider whether it is an Appendix FM, whether it is an
It's
Article
nothing
8.
to do, I'm sorry, it's nothing to do with Appendix X7. If this woman is genuinely coming for medical treatment and genuinely intends to go back, it's not contrary to Article 8, says the tribunal, because there's no legitimate aim in stopping short-term visitors at private expense from coming for medical treatment. So FM has got nothing to do with it. And my simple question is, who decides whether she's lying or telling the truth? That's the question that I want to know about. Who decides for the visitor visa medical policy rule whether she really doesn't?
But it is the entry clearance officer.
It
that
is
is
the
the
clearance officer.
Yes. It is the entry clearance officer, and that is it. Now, what is being
If
said?
you want to challenge that, you've got to go by judicial
UTIAC.
review.
So what is being argued against me is that my submission is well, inconsistent with TZ.
It's not. It's got nothing to do with TZ.
So well, that's all really. I mean that is the submission, and that is how I seek to distinguish.
They're just very different schemes, as my lord says. I mean, there doesn't seem to be any clear guiding principle, but there does seem to be a sliding scale of different different types of decision. But if you look at the visitor visa rules and the guidance, which I've unfortunately had to do quite a lot recently, it's quite clear that the decision, the value judgment, is taken by the entry clearance officer. It's that's the person you've got to convince that you are a genuine visitor,
Yes.
not the tribunal.
Not the
It's the entry clearance officer who then produces a sort of template letter saying, I'm not satisfied for the following reasons. You then challenge that decision, usually by JR.
Yeah. Well, indeed. Now, if I'm wrong in that submission, then that, as I submitted earlier, would create some very serious problems. So this is one visit visa application. Take example of a student or a business person or a skilled migrant. We will be in a position where the tribunal would be deciding whether someone is a student, whether they have made academic progress, whether they have funds, whether someone is a genuine business person, whether they qualify under the rules. And that would simply defeat the obvious purpose of the amendment by the 2014 Act. That cannot be right. If I may just show you.
But I've got that seems to be directly contrary to what the Secretary of State submitted in Spence. It's not.
No, it's not. So Spence, my lord, you will recall that the jurisdiction point, and please do forgive me for answering the question. You know nothing about the case of Spence. So this jurisdiction point was not taken by the Secretary of State before the First-Tier Tribunal.
No, when we wrote to you beforehand and said, shouldn't you? And you said, no, we're not, because
No,
you're
it was
talking rubbish.
yes. So it wasn't taken. It
Well,
wasn't
you
taken.
didn't put it like that.
It wasn't taken by the Secretary of State at the Upper Tribunal. So a day or two before the hearing, my lord, as you're absolutely right, you wrote to the parties saying that, well, there is this point. Now, when I had to exercise a judgment there as to whether I should raise a point for the first time that no one has raised previously, when I was already in difficulty by raising a number of other new points. So I took instructions, took the view that and I was at pains to say that at the hearing, that isn't the issue in that appeal. My lord and Lord Justice Singh
But two of us said,
it
well,
wasn't
you're
the
quite right, we don't have to decide it, we shan't decide it. Lady Justice Elizabeth Lane was so shocked, she said, you can't possibly be right. But anyway, that doesn't matter, because we said that we weren't deciding it there because we were troubled that it hadn't been argued and taken. But you
Yes.
are arguing it here, and you're saying the value judgments here as to whether or not somebody is or isn't going to leave at the end of the stay is for the ECO, and the tribunal work on that basis, and they don't go behind that basis.
Now, well, given the questions, I think I sort of feel obliged as I felt obliged the other day. is to, and fairness to learned friends, perhaps simply to tell what actually happens in practice. Lord is absolutely right that there is a dividing line, a sliding scale approach that is taken. But in practice, this is happening for many, many years, the tribunal decides whether the Article 8 rules are met. And in this appeal, I take no issue with that approach. I seek to distinguish TZ on the basis that TZ is about an Article 8 rule. But if it's not an Article 8 rule, then the Secretary of State's decision is final, but subject to public law. So in the supplementary authorities bundle, just to make this point good, if I may ask you, respectfully, to look at tab 2. This is the short supplementary authorities bundle with 5 tabs. Behind tab 2, you have section 82 of the 2002 Act as it was immediately prior to the amendment. And you'll see that prior to the amendment, there was a right of appeal against subsection 2B, refusal of entry clearance. There was a right of appeal against refusal of entry clearance. There was right of appeal, this is subsection D, against refusal of leave to remain under the rules. And if you go to go to section 84, you'll see that that section identified the grounds on which appeal was available. And one ground was that a decision is not in accordance with immigration rules. So the Secretary of State refuses an application because the requirements of the rules are not met. The tribunal decides whether the requirements of the rules are met because there is a right of appeal against the decision to refuse entry clearance. And a ground that is available is that decision is not in accordance with the immigration rules. Now, section 82 is amended to delete everything apart from the refusal of, and then substituted by the words refusal of a human rights claim. You have seen section 82 already. May I just show you the new section 84 as well, which sets out the grounds on which a person can challenge the human rights, refusal of a human rights claim. So tab 2 of the authorities bundle, page 7. And it is subsection 2. An appeal under section 82 1B, which is refusal of a human rights claim, must be brought on the ground that the decision is unlawful under section 6. Page 7, tab 1.
I just haven't got that. Can you give me that?
My apologies. So tab 1 of the authorities
The
bundle.
main
Oh, the main
authorities
bundle.
Main
bundle.
bundle, my apologies.
Just get that.
Yeah.
It's my fault.
Must be brought on one of the following. Is it subsection 2?
Subsection
84 2.
Yes.
Yeah.
So, Milady, you are at page 7 of the original
Yes.
main bundle.
Must be brought on the ground that the decision is unlawful under section 6.
So, it is beyond doubt that the scheme, the reason why the 2014 Act was introduced was to abolish the right of appeal against a decision taken under the immigration rules. The intention was to abolish the tribunal's jurisdiction to decide whether or not the requirements of the rules are met. And if the tribunal brings back that jurisdiction in this way, then the tribunal is defeating the very purpose of the legislation. And that cannot be right. So the answer to ground 6, in my respective submission, is that the Secretary of State decides, the anti-clearance officer decides whether the requirements of the rules as a visitor are met. It's not the tribunal. But in the event, Lady Milords, that I'm wrong in that submission, and you take the view that the tribunal decides whether the requirements of the rules are met, ground 7 is that in this case, the tribunal erred in law in holding that the requirements of the rules as a visitor were met. So may I show you the rules then for entry clearance as a visitor. So tab 3 of the authorities bundle, you have Appendix V to the immigration rules. And it sets out certain requirements. And one of many requirements is at page 27, genuine visitor requirement. And paragraph V 4.2a is the applicant must satisfy the decision maker that they will leave the UK at the end of their visit. Not that they intend to leave the UK at the end of the visit, but whether objectively they would leave at the end of their visit. They will leave. So the question for the decision maker is whether they will leave.
I think we saw that the decision letter spoke about an intention. Am I right?
Yes. So
Actual decision letter about the intention.
there is yes. So if no, so if I mean, it is in my submission legitimate for the decision maker to consider whether a person intends to leave. If they do not intend to leave, then the decision maker can decide that they will not leave. But the opposite is not correct.
These letters also go out in standard form, and quite often that mantra is chanted.
So
I've
this
seen
is
enough of them recently.
yes. So these are the rules. Can I then just show you an authority that has nothing to do with these rules, but I take you to that because it is cited against me,
Right.
because the tribunal cited that authority, and that is the judgment in Samayanden, which you have at tab 7. So Samayanden, family consideration, a decision by the Upper Tribunal. If
Binding on us.
yes, if you not binding on you, but paragraph 6 will tell you why this judgment has nothing to do with the rules that you're dealing with. So paragraph 6, the tribunal considered paragraph 41 of the immigration rules, which was abolished and replaced by Appendix B. So paragraph 41 stated that the requirements to be met are the following. And the requirement 2 is that an applicant intends to leave the UK at the end of the visit, intends to leave the UK. The whole point of the change in the immigration rules was to change the test from intention to an objective test as to whether a person will actually leave. And this judgment is all about the question of intention. Well, if a person visits the UK regularly, whether it can be said that they do not intend to leave, nothing in this judgment is even remotely relevant to the rule that is now in place. Now, can I then show you the Upper Tribunal's reasoning? Go back to the core bundle, tab D, page 112, where you have the Upper Tribunal's remade decision. And if you look at paragraph, so the assessment is paragraph 112 onwards. The relevant immigration rules are considered. There's no dispute about the evidence relating to medical treatment, etc. Paragraph 113, judges note that unlike other visit visa
Excuse me.
rules, extension of leave to remain in order to continue medical treatment is possible. That I do not dispute, but the question remains whether an applicant will leave the UK at the end of their visit. 114 is where the tribunal refers to Samayanden. 115 and 116 are essentially credibility findings, so I take no issue with them. The sponsor was an obviously credible witness. What she said was true, an accurate reflection of the circumstances. You'll see that the evidence was that the mother would feel lonely and isolated in the UK and would want to return. And 116 is the finding that I say it wasn't sufficient. The finding is that we find that the second sentence, we find the appellant's intention of coming to the UK is genuinely to access medical treatment. We find that she does not want to settle permanently in the UK. The application for private medical treatment is genuine. Well, subject to my other grounds, I take no issue with that. She may be able to apply for an extension. So this is where the tribunal is considering the question of intention. And then the conclusion is that, well, we find that the appellant is a genuine visitor who will leave at the end of her visit. Now, one difficulty that the tribunal has sort of completely failed to grapple with is how she will return to Gaza. The daughter's evidence was that she cannot go to Gaza. There was no evidence before the tribunal, none whatsoever, that entry to Gaza was possible. Well, my learned friend, of course, would disagree with that and would submit that there was evidence, or there is evidence that it was possible. But a question that the tribunal should have grappled with as to how she would return. Will she take a flight back? There are no flights. Will she go illegally through different countries, through Rafah border and through Egypt and take a road journey and somehow enter Gaza?
How was the plan that she was going to get out?
That is the submission. That is the submission that I made to the tribunal. That how will she return?
There is evidence about how she would get out, because there was all the argument about whether there would be what's called this predetermination. She would have to provide her biometrics because there isn't anywhere in Gaza to do it. And the plan was that she would go to Cairo and get her biometrics in Cairo. So the plan was to get out through Rafah, and in other cases, I've seen references to either going through the border post with Egypt, or in other cases they've said, well, no, we'll actually smuggle somebody else or we'll bribe somebody else. And I just don't know what the facts in this case are.
Yeah. So if, for example, the appellant had said that, well, I have a visa to reside in Turkey, and after a short visit, I'm going to go to Turkey with my other family members, and I will live in Turkey. A different question altogether.
It's just the problem with Gaza because of the conflict zone.
Exactly. So no suggestion that she will go elsewhere. How is it that it is possible for the tribe for her to return? Is the question that the tribunal failed to consider, and they conflated the intention to return with the subjective requirement that an applicant will return at the end of their visit.
Notice that they refer to the guidance. Have we got the guidance, the policy guidance in the bundle?
Yes. Yes. So in the so I've taken you to the human rights guidance.
Yeah, I was thinking about the visitor, the Appendix 5 guidance.
Yes. So that is tab 25 of the bundle.
Thank you. Just remind myself of that.
Let's have a look at the
25.
So tab 25.
multitasking.
The genuine visitor requirements are dealt with at page 510. And you'll see that the guidance says that, well, there are factors that will assist. Previous immigration history is relevant.
Duration of previous
So is
visits.
duration of the previous visit, financial circumstances, personal economic ties with the country of origin, etc. And then page 111, you should look at the stated purpose of the visit.
Sorry, then, which page?
So page 511, the history of the applicants, and you have a further list at page 512.
It's just that when the tribunal were dealing with the previous tribunal decision, they referred to intention, which of course was at the heart of it, but they also referred to the guidance, and I was just checking to see if there was anything in the guidance about intention. And not surprisingly, I haven't found anything because it's not the test.
It is not the test, of course. There are provisions as to the credibility of the application, etc. So if
There is reference to intention, isn't there?
Yeah.
That's the first major headline on page 510, assessing an applicant's genuine intentions to visit.
so, it is as I
And then there's another
the only
one
thing you've
later
got
on 512, credibility and intention
Intentions, yes.
of decisions.
so under the previous rules, the question is simply the intention to return. Under the new rules, the question is whether a person will return. To that question, what is relevant is credibility of what is being said, the intention. So the person does not intend to leave, that means they will not leave. And the requirements of the rules are not met, but the opposite isn't true.
I see that. I was just wondering whether this guidance is dated the 31st of January 2024, so it was the one in force, but did it reflect the change in the?
Yes, so yes,
That's what I meant.
yes, so this is the guidance about the new rules, but it does not say that, it's quite clear that intention is the test or the sole criteria.
It's a factor.
So the
It
short,
doesn't say there may be cases where whatever
it doesn't.
they think they want to do, they may not be able to achieve it.
No, but yeah, I'm not.
Which is your point.
Yes, but it says categorically that, well, these lists are not exhaustive.
Yeah.
So the short submission, ultimately is that when someone is seeking to come to the UK from a conflict zone, the tribunal must decide, the decision maker must decide, subject to my ground 6, as to how they will return at the end of their visit. If return isn't possible, then the conclusion that they must reach is that they will not return, irrespective of what they say about the intention.
In order to satisfy the authorities. I just read very quickly again, and I'm sure Mr. Tamika will take us through it, the 3 letters from Bynum's to the Home Office. They explain her commitment to Gaza. They don't say how she's going to get back to Gaza, and they describe the conditions in Gaza, where she's living, the bombing in Gaza, the exclusion orders and so on, but there's nothing about how she's going to get back to Gaza. But I really read through it. I mean, I read it last week, but I've just gone through it again whilst you were looking at the guidance. I hope I didn't miss anything in the
We
guidance.
didn't miss anything in the guidance.
So I mean, ground 6, the entry clearance officer decided that, well, she does not intend to leave. One of many conclusions, and the requirements of the rules are not met. Ground 6 essentially is that is it. That is a question for the entry clearance officer. But ground 7 is that if it is not the question for the entry clearance officer, then the tribunal erred in law in holding that the requirements are met. The final ground 8, is about proportionality assessment. And may I just show you how the Upper Tribunal conducted that assessment. So tab D of the report bundle again. Page 112 is the Upper Tribunal's decision, and page 131. You have one paragraph. In our view, the tribunal said this is determinative of the appeal. Well, because she's a genuine visitor, as submitted by my learned friend in accordance with TZ, the authority that I've shown you, and there is no public interest in refusing her entry clearance.
What about immigration control?
Yeah, so the submission is that,
Wrong with 6 and 7, it's not a legitimate interest to stop people coming for medical treatment. So what's the legitimate aim? What's the justification under 8.2? What interest is being served?
um,
Not going to reach immigration control. She'll
Yes.
get a visa and she'll go back.
Yeah.
On this analysis.
so the Secretary of State's policy is, as to Article 8, is set out in the immigration rules, in Article 8 immigration rules. She has formulated rules that allow people to come and meet and stay with their family members in the UK. That is the Secretary of State's policy. And that is the policy by reference to which the tribunal must conduct the assessment of proportionality.
If she's coming to stay here, but she's not on this analysis. On this analysis, she's coming in, she's having the operation, and she's going back. And there's nothing in the rules that says that's undesirable. She's allowed to if we lose on 6 and 7. That's the simple argument. There isn't a legitimate interest which is being served because the rules have said you can come in for that.
But
You have to be excluded.
but you're allowed to come here as a visitor, yes. But the tribunal is saying that, well, you are allowed to come here on Article 8 grounds.
I don't think they're saying that. I think what they're saying is they've accepted that Article 8.1 is applicable because it's an interference. So the Secretary of State has to justify it, and she has to establish a legitimate aim, and that the action taken to achieve that aim is proportionate. And they're saying there's no legitimate aim because you can't say you want to stop people coming in as visitors for medical treatment because your rules say they should be able to come in for medical treatment. That's all the tribunal is saying.
Well, this is, of course, tied up with the submissions that I was seeking to
6
make.
and 7, you either win in 6 and
Make-
7 or you don't really, I think.
Make it earlier. So make the same submission that I made in response to, in relation to ground 6. The Article 8 immigration rules reflects the government's view as to how balance is struck, or the proportionality balance. And if those rules are met, then there would be no public interest in declining someone to enter the country on Article 8 grounds. If those rules are not met, and a person qualifies under some other category of the immigration rules, it would be desirable for them to allow to come to the UK. The Secretary of State would be or could be obliged to allow them to come to the UK as a visitor or as a student. But in my submission, that does not answer the Article 8 proportionality question that is raised.
It's a bit strange because if Article 8's engaged, tribunal will be thinking, is not allowing her to come here a disproportionate interference with her Article 8 rights, either private life or family life, and have to decide one way or the other. And it seems to me that the question whether she meets the immigration rules for some other reason doesn't factor into the Article 8 assessment at all at the moment. Either it's a disproportionate interference or it's not. This is where I'm getting a little bit worried about how it appears to be that the Upper Tribunal is utilising an Article 8 argument to give itself jurisdiction on an appeal to determine something that would actually be normally determined by JR. Because the whole question of whether she complies with the rules for visitors' visas, which would be down to the entry clearance officer, is something that you would normally only be able to challenge by JR and not by appeal. We're back to your earlier point.
Ground 6 and 7.
It's back to ground 6, yes.
It is ground 6, and yes, I mean, if an approach is it in that way, and that would reinforce, in my submission, the submission that I'm making on ground 6. In the event, of course, that you're against me on ground 6, then accepting the approach that is set out at 118 would lead to the sort of very serious problems that I've identified earlier. So it's either ground 6, and if not ground 6, then ground 8. But one way or another, giving itself jurisdiction, which Parliament intended to abolish by the 2014 Act, is wrong. And TZ is distinguishable because TZ is about an Article 8 rule, where an Article 8 rule requirement is met, the position is different. But where requirement of another rule is met, the position in my submission is different. And that then ties up in my submission with considerations in section 117B of the 2002 Act. The court knows about the provision which says that the tribunal must take into account certain factors. None of those factors have been taken into account in assessing proportionality, because the tribunal took the view wrongly in my submission that the requirements, meeting the requirements as a visitor is enough. And for that reason, in the event that I fail on all grounds 1 to 7, I respectfully invite you to allow the appeal on ground the final ground. Now, you asked a question about disposal, so I do ask you to find an error of law if there is jurisdiction to say that Article 8 is not engaged. But in the event that Maleficent persuades you to find that Article 8 is actually engaged, I do ask you to consider the question of proportionality as the court did in IA, and find that the interference would be entirely proportionate, because the Secretary of State has decided that the requirements of the immigration rules are not met, and there are no very exceptional or compelling circumstances here. Unless I can assist you any further, these are my submissions.
Thank you very much,
Okay.
Mr. Malik.
My lady, my lords, thank you very much. I'll just take a moment to get my things in the right place. So I will, like my own friend, Mr. Malik, I'll follow the grounds in the order in which they're pleaded, and I will divide them up to try and avoid duplication on procedural history and facts. Can I just start by identifying one or two points which have come out of this morning's submissions and the interventions of the my ladies and my lords' interventions. So on the and I think dealing with some of Mr. Malik's submissions about the terrible complications which would ensue if the tribunal's approach was correct. So firstly, there's the question that my lady raised about how does the tribunal avoid having masses of completely hopeless Article 8 claims before it? And we say the answer to that is found in the statutory scheme and not in the Secretary of State's policy. And the statutory scheme provides the Secretary of State with the power under Section 94 to certify claims as clearly unfounded. That is the way the Secretary of State avoids claims, unmeritorious claims coming before the tribunal, and that's the way that Parliament has discouraged people from making unmeritorious Article 8 claims in order to try and get student applications before the tribunal, for example. What the statute doesn't provide for and doesn't support is a published policy by the Secretary of State which creates arbitrary, bright-line rules in order to exclude the
Are you challenging the policy?
No.
It's unlawful.
No.
Where is section 94?
It's in the my lady, my lords, I'm just dealing with these as headlines. I'll take you to them, but it's in the supplementary bundle of authorities. It's the first tab.
You can't bring an appeal if it's been certified as unfounded.
That's right.
Yeah, okay, it's 94.3.
And that's the way in which unmeritorious claims are kept out.
But that's usually used, isn't it? Where the merits have been engaged. In other words, it's got to be accepted it's a human rights claim in the first place, and then it said, well, substantively, you're not going to get this off the grounds, so we're going to treat it as clearly unfounded.
Melody, I'll come back to that and
Okay.
what the statute says about what a human rights claim is and how the policy, and again, we say that the policy, a Secretary of State's policy can't undercut statutory provisions, particularly when the provisions are about the jurisdiction of the
Sorry, I
country.
didn't hear about half of that because of the noise of the
Oh,
fan.
I'm
You're
sorry,
going to
I'm
have to
going to-
stand.
I'll
You're
try
going to
and
have to
lean
shout
forward.
a little bit more. I'm so sorry.
I'm not very shouty. My lady,
Strain your voice.
it's another example. So we say that it's the statute which creates, which defines what a human rights claim is, not
Yes.
the policy.
Yes.
And that as a bottom line, statutory provisions which create jurisdiction can't be undercut by policies. Secondly, we say that another clear bar to the arrival of a large number of unmeritorious claims is the strict and clear application of the additional elements of dependence requirement. And that's the way in which human rights claims can be disposed of straightforwardly, including by certification if the Secretary of State wants to do it. She didn't in this case.
The tribunal, do they have a power to strike out under their tribunal rules? But the FTT says hopeless. They've got to go through it. The other way forward. There isn't.
My lord, I think
there's no strikeout power.
I think the Secretary. I think that a tribunal does have to go through it, but I can take instructions, so I can check that over. But that's not, of course, it's not a situation which arises here. My lady, just in answer to the point, are we challenging the policy? Of course, I'll come on to this, but it has been common ground in both the First-Tier Tribunal and the Upper Tribunal, not withdrawn by my learned friend, I think, that a human rights claim was made, and we say it's straightforwardly and clearly true by operation of statute that a human rights claim was made. Had the Secretary of State relied on her policy in order to submit to the First-Tier Tribunal or the Upper Tribunal that no human rights claim had been made, then it may be that issue would have arisen, but it's too late for it to arise now, we say. So no, there isn't a policy challenge. It doesn't mean that we agree with the policy, but it's not necessary to challenge the policy in this case. But I was on my second point, which was that the way in which the kind of family life application and family life visit application is which can be an Article 8 claim is restricted is through the law about family life, not through the Secretary of State's policy about visitors. And I will come up with some more examples of visits which might engage Article 8, which aren't just about parents to minor children or spouses. Again, they're theoretical examples, but one of them will be this case. Thirdly, on top of that, the arguments that my learned friend has raised now, which is that what the tribunal has done in this case risks flooding the tribunal with disguised appeals, immigration rule appeals, so disguised pre-2018 immigration appeals disguised as Article 8 claims is again simply wrong. The way in which the tribunal exercises its jurisdiction is to decide whether a human rights claim has been made, and to decide and to make findings on all facts which are relevant to that decision. And that's Section 85 of the 2002 Act as it presently stands. I'm going to arrange for copies of that to be handed up after the break. Fourth point is that my learned friend's submissions, and I certainly had not understood him to be making quite such a radical submission as he is today about the jurisdiction of the tribunal and the fact-finding jurisdiction of the tribunal would represent a massive restriction in the powers of the tribunal to make findings of fact, and it would be a massive restriction for which there is no outline. My learned friend's not been able to identify an outline around the facts which a tribunal is entitled to find and the facts which it's not. So on the one hand, there's the example in the Spence case of whether someone's exclusion from the UK would be conducive to the public good. It's quite easy to see how that's the kind of decision for which there would normally be a high level institutional respect for the opinion of the Secretary of State. At the other end,
One thing, who decides ultimately? It's one thing to say I'm going to respect your decision, but I'm disagreeing with it. Another thing to say it's not your decision to take First-Tier Tribunal.
yes,
Secretary of State has decided she doesn't want child molesters to be allowed to come into the United Kingdom. Is that her choice, or is it her choice subject to the First-Tier Tribunal overruling it?
so we say that the tribunal's role is to make findings of fact, and it's to make findings of relevant fact. And findings of relevant facts include a finding about whether two people are genuinely married. It might include a finding about whether someone genuinely has, or whether someone lied in a previous application for entry clearance. It might include a finding, we say, about someone's intentions, and that's a finding of fact. The courts make findings of fact. It's not an evaluation in the same way. Of course, I understand it's a finding of inferences drawn from facts, but it's not an evaluation like a finding that it's conducive to the public good. And so, but my first concern, really, in response to my own friend's submissions, is he hasn't provided a model or a principle by which we distinguish. Yes, an organising principle. But insofar as, and I would invite you to be very slow to give judgment on a matter which would very significantly potentially restrict the powers of a tribunal to make findings of fact in circumstances where we have not a single authority from the last 10 or 12 years before the court, where this court has struck down a tribunal's decision because it made a finding of fact about compliance with the rules. Findings of fact about whether people had lied in their in their English language requirements and all this kind of stuff.
Well, the whole TOEIC saga and the whole purpose of sending it off to a First-Tier Tribunal was precisely so that the disgruntled person who was accused of cheating could have a fact-finding as to whether they were being truthful about having done the test or not.
So we say that for exactly the same reason, but that's in the context of an Article 8 claim. Again, those are all post-2014 decisions, and they're in the context of a jurisdiction which is founded on Article 8. And the approach of this court was that a person has a right to a fact-finding about honesty. And we say the same thing. If a case turns on intention.
Well, there was an artifice about it, wasn't it? They were treated as if they had made an Article 8 claim, though 9 times out of 10 you couldn't work out on what possible basis they could make an Article 8 claim because they hadn't been here long enough to establish a private life, but that's another matter.
My lady, I think it is another matter. Just on the, I agree that I'm not trying to say that there's a direct factual parallel or that there's any kind of factual precedent. My point is simply that
you're saying the tribunals make fact findings all the time. They're supposed to make fact findings, and we should be very chary about trying to lay down any sort of bright line as to what they can and can't do.
Yes, and what follows on from that is that one of the findings that a tribunal must make is, or what a tribunal, one of the things that we know a tribunal is required to do under Section 117B of the B1 of the 2002 Act is to have regard to the fact that immigration control. I'm paraphrasing something.
I mean, this is why I've always been bothered about this, despite all the previous cases saying don't worry about it. It's easy now with Section 177B in Part 5A because it says when a court or tribunal is deciding Article 8, it must do the following. So it's clear that the court must determine significant obstacles and so on. But the point that you would want to make is they were doing that before the Act when it was in the rules. And what's the difference between deciding significant obstacles in the rules and deciding we'll leave at the end of the medical visit? Your case is that they're not dissimilar.
So we're saying the Secretary of State has got to decide the weight to be attached to the public interest in immigration control, using that shorthand. And in order to decide that weight, the Secretary of State has to decide, is there a legitimate aim being pursued? And in order to make that decision, it has to decide, does this person fall within an immigration rule? It's the way in which the Secretary of State approached this case in the hearings below as well. But so the Upper Tribunal, just to give an example here, couldn't have heard evidence from witnesses who were cross-examined, both in the First-Tier Tribunal and in the Upper Tribunal, made findings that they were credible about various things, but then be required to ignore those findings in response to the Secretary of State's submission about the weight of the public interest. It simply can't do that. The Tribunal is required to make findings of fact about matters which are relevant to its decision. A matter which is relevant to its decision is the strength of the legitimate aim in any individual case, and that strength, even without going as far as we do in resisting ground 8, on any view, the strength of the public interest is going to depend on the extent to which a person falls within an immigration rule or not. Because that's the whole way, the way in which the Secretary of State exercises the immigration control is by giving effect to the rules. So within the Article 8 balancing exercise, the Tribunal has to make a finding as to the legitimate aim which is being pursued and to the weight to be attached to it. And it can't do that without making a finding about whether someone, for instance, intends to leave or intends to overstay. And so we say that was straightforward. So the Secretary of State, again, just even backing off from the rules, in determining any Article 8 claim, the question whether someone intends to breach immigration control in future or not is plainly relevant, we say, and the Tribunal would have acted unlawfully in shying away from making those findings. For those reasons, my own friend simply can't make out his argument that the Tribunal should have shut its mind to or made findings.
And the Act things would have been clear before, because they have to decide in accordance with the immigration.
I'm so sorry, I missed the start of that sentence.
Why has Parliament amended the Act? Because previously it was clear they had to decide in accordance with the rules. And I think their powers were to say the rules should have been exercised differently.
So,
and that's gone now.
So, because, just giving an example of students, so visit visa applications were always under a slightly different regime because they were a right of appeal for a long time only arose in family visits, and they were quite broadly defined family visits. They would have covered this visit, they would have covered parents. But let's imagine student visas. Prior to 2014, the 2014 Act, anyone who had a refusal of leave to enter or entry clearance as a student or a further leave to remain had an automatic right to appeal to the Tribunal. And they didn't have to establish any kind of Article 8 claim to get in through the door. It's clear that the overwhelming majority of student visa applications couldn't raise any kind of arguable Article 8 claim. Those are all out. And that's that was the purpose of the Act. So you take away the power to get a second decision under the immigration rules in all cases, which is what the previous right of appeal. So the previous right of appeal not only gave you the right of appeal against the refusal of the majority of immigration decisions, but also gave you a ground of appeal, which the decision is not in accordance with the immigration rules. So you had the right to go to. I had the right to go to court and say, you've refused my application under the immigration rules, and your refusal was wrong. And I didn't have to go anywhere near Article 8 or anything else. And what's happened is that that power has been taken away. But we say that so all of these changes came into effect at the same time. So on the one hand, all of those different appeal rights were taken away, and the jurisdiction of the Tribunal was restricted. But on the other hand, Section 117B was brought in, which reminded tribunals that they had to have regard to immigration control and therefore the amount of weight to be attached to it. And Section 85(4) was brought in, which reminded tribunals that they had to make findings of fact about all matters which were relevant, or they could make findings of fact. They had a power to make findings of fact. So we say the statutory scheme continues to provide for the tribunal to make findings of fact about all matters which are relevant to Article 8 claims. I'll come back to all of this, but I just wanted to deal with all of those while they were quite fresh. Can I go to ground 1 first, the jurisdiction point? So I've already So a lot of this is common ground. I've already indicated. We all agree that the only relevant power of the First-Tier Tribunal is to hear an appeal under Section 82(1)(b) of the 2002 Act, and to decide it by reference to Section 84(2). I will ask you to go back to tab 1 of the authorities bundle, if I may, but for section 113.
Yeah.
So that's the definition of the human rights claim, and it's Mr. Malik took you to it in response to a question from my Lord Justice Lewis. It's a really probably over simple point to make, but on page 11 of the bundle, a human rights claim includes no reference to merit, and that's the point that my Lord also took. So the statutory intention, the parliamentary intention, is not that at the time of deciding whether a human rights claim has been made, there should be an assessment of the merits of that claim. And I don't need to take you to it, but in MY Pakistan, which you have before you, Lord Justice Underhill reminded us that would be unlawful under Section 6 of the Human Rights Act can just be rephrased as would breach my human rights. That's what I mean. So that's the claim that has to be made.
Is it your position that it's enough to say, so if you take that literally, a person says to the Secretary of State, refusing me entry is going to be a breach of my Article 8 rights. Is that good enough to make it a human rights claim, irrespective of whether it's obvious nonsense?
So, my lady, I don't think it's necessary for the court to determine that for the purposes of today. We'd simply say that what if you read that alongside Section 94, you see the statutory intention, which is that the answer to a claim like that is an immediate certificate.
What you say is that on the facts here, there was lots of reasons why this particular case fell within it, and the parties accepted that in the decision.
Yes.
I think what would be most helpful for me is to find out why you say, or how you meet Mr. Malik's contention that there was no refusal of the claim. There was I'm not engaging with it. You can't possibly have Article 8 rights. I'm just not dealing with it.
Yes, well, I'll come on to that.
I think the key.
But I don't want to try and deflect the question that my lady's asked. The statutory answer to the question is that Section 94 provides the power. So the Secretary of State, on any view, if someone writes the Secretary of State and says, my refusing me leave to remain would breach my Article 8 rights because I like beer, British beer or something like that, and the Secretary of State will still have to deal with that. Can't simply ignore it. So the Secretary of State will deal with it.
Then be appealed unless it's certified.
But the Secretary of State will write back and say, I see you've made a human rights claim. It's clearly it has no prospect of success at all.
But I think the Secretary of State could say, I'm not prepared to deal with this piece of paper at present because insufficient information is provided for me to do so. So you could, I think, have a situation where no act of refusing has occurred. There has been an act of deferring consideration. And I know you don't want to get to it, but it seems to me the key question is whether this decision said, I don't think you qualify, so I'm refusing it. It being either the visa or the claim, or was he saying, no, I'm not even dealing with this because it's nothing to do with Article 8. And you've really got to address that, Mr. Tariq.
Yes, I'm going to, but just in answer. So the Secretary of State could say, as the Secretary of State did in NY, you put that on the wrong form. There could be formal requirements under the rules and so on. But my Lord, I won't spend a long time on the question whether a claim was made because it was common ground. But it's still important to understand that. We say that the statutory framework allows for two things to happen. It allows for the Secretary of State to prescribe forms, and it allows for the Secretary of State to certify claims which are unfounded. And those are two ways. So prescribing forms effectively is a deferral. It's a way of deferring. I don't want to make any concession as to whether the Secretary of State could simply say go away and send me a better application, because and whether that would or wouldn't amount to a refusal. It's not what arises in this case. I think that my lady, my lords have the submission we make about how a human rights claim is decided, and we say that we have to look at whether a human rights claim has been decided through the prism of how you can recognise a human rights claim decision, and the way that you recognise a human rights decision, we say, is through the Rasgar questions. And so you have those. I don't think I need to take you to them because you're familiar with them, but just so you have the reference, it's tab 5 of the authorities, page 65, paragraph 17. The first question that has to be grappled with is whether family or private life, relevant family or private life, which requires respect, has been shown at all. The second question is whether there is an interference of sufficient gravity to require justification. And you have a reference in the supplementary bundle, sorry, page 3114. Again, you don't need to turn this up to save time, but the phrase consequences of such gravity posits no particularly high threshold for Article 8.1. It reflects the fact there needs to be more than a technical and consequential interference. So of course, the BA case would give rise to refusal on both 1 and 2. My Lord, I am going to come to it. So the Rasgar, so if you can see that a decision has substantively engaged with one of the Rasgar questions and reached the point where the answer to those Rasgar questions means that the substance of a claim has been grappled with, then you have had a decision on the claim. That's the submission I made. Rasgar 18, which is also on page 65 of the bundle, I think it might be worth turning that up. So sorry, it's tab 6, page 65, paragraph 18. Yes, it's a certification claim, so we can ignore this was a clearly unfairness, but that's not relevant to the questions about what Article 8 requires. If the answer to question 1 clearly would or should be negative, again, that's a certification question. But if the answer to question 1 is no, there is no family life, there's no ground at all for challenging the certificate, you don't have to go any further. So if you have the Secretary of State saying, I don't believe you've got family life, or I don't believe you've got family life in the meaning of Article 8, then that's the end of it. She doesn't have to go on and say, and I don't think I'd interfere with it, and in any event of proportion that she can choose to do that if she wants to. If the Secretary of State has said, I don't believe this is protected family life, then she's made a decision on the claim. My Lord, I think that's the point that my Lord put to Mr. Malik earlier on. And our submission, when we come to the decision, is that's precisely what has been done in this case. The Secretary of State has said, not a family life which is protected, therefore I'm refusing your Article 8. And we said that's the only proper way. Whatever she says about it, whether she says I've got a policy which means you haven't made a claim at all, makes no difference. She can say what she wants about the decision. If as a matter of substance she said that's not a protected family life, that's the end, that's a decision. I'd like to make 2 more observations about family life just while I'm in this, and before I take you back to a couple of cases on jurisdiction. Firstly, because it's relevant, EM Lebanon is in the second authorities bundle, tab 3, starting at page 13. And could I just take you to page 30, paragraph 36. It's a convenient summary of the principles about family life and its importance. Still good law. So 36, mutual and it's the examples given here are about child and parent in paragraph 36. Mutual enjoyment of company, fundamental element of right.
Minor children here, isn't it?
Well, that's yes, that's example, but that's why I'm going to take you to 37, my lady. But so the love trust, just towards the bottom of 36, is absolutely right. That's the starting point. The love, trust, confidence, mutual dependence, unconstrained social intercourse, which are the essence of family life. And then Huang, human beings are social animals. They depend on others. Their family or extended family is the group which many people most heavily depend, and so on. And then on to paragraph 37, and this is why I wanted to take you there. Families differ wildly in their composition and in the mutual relations which exist between the members, and marked changes are likely to occur over time within the same family. There is no predetermined model of family or family life to which Article 8 must be applied. And just to say, we say that if that if the Secretary of State takes a decision, you don't fit within a predetermined model, therefore I'm refusing your claim, then firstly, she is refusing a claim, and secondly, she's probably doing so unlawfully. The article requires respect to be shown for the right to such family life as is or may be enjoyed by the particular applicant or applicants before the court, always bearing in mind the participation of other members who share in the life of that family. And that's the bottom line, sort of most authoritative reminder that there is no bright line rule around protected family. The other, I think I was going to also take some points in IA and others, but I'll save those so that I only have to go through there once. So then 2 cases on appeal rights, and then I'll
Maybe Mr. Chirico, it would be better to deal with those at 2.
Yes.
Thanks very much.
I promise, my lord, that I will answer this question. I've hopefully flagged up what the answer is going to be, but I'll try and make that answer good by reference to the text. Thank you.
For table